Hi, everyone, and welcome once again to one of our Hobby Memorial Library events. We have a very exciting talk on the Constitution, and we have with us today Dr. Anthony Jordan. He is from the Behavioral Science Department, Government. He'll tell you who we are. So we're going to get started. Welcome, and thank you very much again for doing this for us.
You're welcome, Cindy. As noted, I'm Anthony Jordan, PhD, Professor of Government here at CTC. Been called into action here today in Constitution Day, so I got a few notes here. I'm going to be exploring the idea of incorporation. Also, what I tried to do is I tried to challenge myself. I tried to work exclusively with our assigned textbook for our federal government course, The Enduring Democracy by Daughtry et al. So I tried to limit myself to that. So anyone who's currently in federal government here may get some benefit from it, may see some familiar things, maybe helps you understand it. So where I'm going today is incorporation. You may also hear it called selective incorporation. Depends on the author. We do not have a set way to refer to it. There's no major way to understand it. Just some go with one term, some go with the other. What this term means is that the Bill of Rights and the Constitution, slowly over time, after the ratification of the 14th Amendment, via various court cases, so a lot of court cases today, is that these rights are going to be interpreted as, well, actual rights. Once you identify something as a right, it applies to everyone. If it's something less than a right, then that means the state can regulate it how it sees fit. So this is going to be interpreted, reinterpreted. Sometimes we double back over ourselves. Sometimes we just keep narrowing. Sometimes we broaden. Honestly, there's way too much to get into to fit it in 30 minutes, to fit it in an hour, to fit it in a week. I'm going to hit a few things. So my goal today, I'm going to look through the First Amendment a little bit. I'm going to look at religion and expression, two big parts of the First Amendment. Then we'll look at a little due process, so a little Fourth, Fifth, and Sixth Amendment. And those are big things also covered in our text, which, if you're taking the class, hey, this is a chance to kind of double up, get a little more. So I'm going to bring some cases with me. I have my notes jotted because some of these, I know the theory, but if you want me to quote, scripture and verse and case and line, gets a little tricky. So let me start with the First Amendment. And we're going to start with this idea of freedom of religion. It's based in two parts in the First Amendment. There's the free exercise clause. You're free to exercise what you want, whatever that is. And, if you choose not to use it at all, that's your choice as well. I mean, that's kind of the origin of why people even came to this continent from England, seeking religious freedom. We want to practice what we want to practice. Well, free exercise clause states that pretty clearly. Second part is the establishment clause. The United States can't establish a church. For instance, we left England. They have the Church of England. Why do we have it? Henry VIII wanted to have a divorce that the Catholic Church wouldn't sanction, so he said, heck with it, I'll make my own church. By golly, he did. But we didn't want that. We also didn't want the state to favor any church over another, because that's what was happening in England as well. I mean, if you're from a smaller religion, if you're a Lutheran, you're going up against the Church of England, gee, I wonder which one the British government's going to support. So we want all religions to be treated equally and have no favoritism. Of course, when you put pen to paper, we ratified this amendment along with the first 10 altogether in the Bill of Rights, simultaneously in 1790, it makes sense. Like any plan when you put it on paper, it makes sense. Then you give it to human beings, then the next generation, next generation, next generation, so on and so forth. We don't understand it as well as we thought we did. Or maybe circumstances have changed. Certainly people have changed. So we have to figure out what happens when something appears to conflict with the First Amendment, particularly what state action conflicts with the First Amendment. And is this actually a right, or is this not really part of the First Amendment and the state can regulate it? So I'm starting with Sherbert v. Werner. And this is going to be a case that I believe comes out of Pennsylvania. A lot of Midwest coming out right off the bat. And in this case, it involves the Seventh-day Adventists. And a big part of their religion is you don't work on the Sabbath, Saturday. Well, this is going to be an issue. Why? Well, if you want to collect, state welfare, state unemployment, or if you're even just seeking employment, saying, hey, no Saturday whatsoever, it's going to be hard to win that through. And the state wasn't supporting the church. The state was saying, no, if you're going to outright refuse to work one of the days of the week and have no flexibility, if they don't want to hire you or if they choose to fire you, or if you don't want to, if you expect to get benefits from the state, it's not going to happen. You intentionally restricted your schedule when you physically could have worked. So this goes all the way up to the Supreme Court. And the Supreme Court's going to look at this case through a couple of lenses. The ones we really care about is there a compelling state interest? Did the state have a compelling interest in denying support and benefits to this individual? The Supreme Court is going to say there is no compelling state interest. So if this person, due to their religious beliefs, does not want to work on Sunday and refuses to work on Sunday, the Supreme Court supported this individual. So the state law was invalidated. So if your religion prohibits you from working on a certain day, Supreme Court's got your back. State can't restrict it. So this is the first step. Once again, I'm kind of following the book verbatim here, so you can follow along with me. Next case, Wisconsin v. Yoder. This is going to involve the Amish. The Amish are going to take, umbrance with a Wisconsin law that says everybody must attend high school. High school is mandatory. What goes on here is that the Amish are saying, no, we need our young people to work, be part of the community. This is our religious belief. And Wisconsin is not respecting it. Wisconsin's going to argue, well, we have a compelling state interest in that we need people to have a base level of education. So it works its way through the courts, gets up to the Supreme Court, and the Supreme Court is actually going to side with the Amish, saying there is no compelling state interest. Saying, yes, the state has a compelling interest to give you levels of education, but they're going to end it after 8th grade. And so the Supreme Court's going to draw the line and saying, if you have a religious exemption to education after 8th grade, you can use it. And this is going to apply to all 50 states because it was decided by the Supreme Court. So this isn't just a Wisconsin thing, it's an everywhere thing. Just so happens there are Amish people up there in Wisconsin, and they challenged it. Next case, Reynolds versus United States. This is a little thorny, and this is where the Supreme Court's going to give us some ideas to help understand how to interpret the First Amendment in the future. This is going to involve the Mormons. And the Mormons, early on, they discontinued the practice before 1900, but they used to believe in polygamy, multiple spouses. And so they put that belief into practice, saying, all right, you can marry multiple people, have multiple spouses. Thing is, most states in the Union have bigamy laws. You can only marry one person at a time. Now, I mean, if you divorce them, of course, you can marry someone different, but you can't stay married to the same people. So what's going on here? Mormons feel unfairly affected by this law, saying, this is our religious belief. How can you deny this to us? Utah is going to say we have a compelling state interest in people not having more than one spouse at a time. They don't agree. They take it through the court system, comes to the Supreme Court. And this is where the Supreme Court's going to draw a clear line that still exists to this today. They're going to say there's a difference between beliefs and practices. Beliefs, they're going to say, is all up here. This area, those are where your beliefs are. Government can't touch that. If you want to believe you should have more than one spouse, by all means, believe it. If you want to have like a wink understanding with somebody, like legally it's one person, but the rest of you are technically my spouses as well, whatever. It's not legal. Government can't touch that. You kind of see cults use this mechanism from time to time. It's a belief. Supreme Court says we can't touch that. State can't touch that. Violation of the Free Exercise Clause. But they're going to draw a line. Practice becomes different. Practices can be touched by state law. Now, it's going to depend on the practice. I can't tell you 100% of the time or 0% of the time because neither one's accurate. But what happens here is that because it's a practice, the Supreme Court agrees with the state of Utah saying it's a practice, so you can regulate it, and you have a compelling state interest, so we're going to back you up on your right to regulate marriage. So the Mormons could not legally have more than one spouse. Now, I mean, they're going to discontinue the practice themselves, but this is kind of setting things up to let us know the courts are really going to make some distinguishing issues here. They're going to distinguish between important concepts. You have to be free to believe what you believe. It's important that you have that freedom. Whether you use it or not is up to you. How you use it is up to you. And if the state says, hey, we have a compelling interest, well, there's not much you can do. For instance, you can believe in human sacrifice. You're like, hey, we need to do this. This is going to appease whoever it appeases. I really don't know. However, the practice can absolutely be barred by the state, and the Supreme Court's going to have the state's back. One, because you're harming someone, and that's usually a big test for the Supreme Court. Does the use of your rights harm another individual? If they do, sometimes the state can step in and limit your rights. We also see this in the famous Oliver Wendell Holmes decision, where he says you can't just yell fire in a crowded theater. Yes, you have the right to express yourself, but in doing that, you're probably going to lead to people being trampled. Now, obviously, if there's a real fire, you have wiggle room because, hey, it's a real fire. But if you're just doing it to cause mischief, well, you can face legal consequences. And don't expect the First Amendment to help you out. So we have to parse this out, and this is the challenge the courts are going to have. How much freedom do we give people? So they're going to create standards, beliefs we don't want to touch. Practices we may touch. If it's harming an individual, we may touch it, if the state chooses to. And then you have some things that thread the needle, such as the practice of snake handling. For any of you who have family back in Appalachia, where this is a thing. I won't get into the whole kit and caboodle, but based on a passage in the Bible, this church believes that, hey, if you're right with the Lord, everything's copacetic, you should just be able to reach down, grab you one of them boys, and you won't be bitten because, hey, you're doing everything right. Lord's with you. And if you get bit, well, you probably sinned and we just didn't know about it. Obviously, that's a belief. You're free to have it. But when you actually practice it, bring your children there, though in their defense, they usually give children, the little tiny slithering snakes that aren't venomous. But still, courts haven't been on their side. Where I say this one threads the needle is that I believe in Tennessee they have outlawed it, and you get hit with a whopping like $150 fine. Okay, and I guess they're against it. I don't know if that's the most harsh punishment in the world, but states have a right to punish it. And by the way, they get away from it by just buying a piece of land, clearing out the middle where no one can see it. So that's how they get away with that. So if you're wondering why is it still a thing, well, really hard to police. How can you police something you don't witness? We'll get to that when I get to the Fourth Amendment as well. So a lot going on with expression. Freedom of religion is important, but freedom of expression is important as well. If we're going to have a system where we can select new leaders, we got to be able to criticize the ones we have. That's the only way that system's going to work. Under the monarchy, that's not really a big deal. Yeah, in the past, you could criticize King George, but kind of at your own peril. And you weren't going to replace him with another king or a queen. Also, this depends where you are in the world. Not sure I'd go to North Korea and, let Kim Jong-un have it. I mean, you can, but we'll probably never see each other again. But in the United States, it's important. The system rests upon it. For us to, evaluate our leaders, decide on whether we want new ones, we have to be able to criticize the government. We have to be able to express ourselves. So when you hear expression, you should often think of it in terms of political expression. Government can't stop you from expressing yourself politically. Once again, we have that caveat, as long as you don't harm anyone. If in expressing my rights, I wind up violently attacking you, court's probably not going to have my back. They're going to say, no, you're harmed. You can throw me in jail, and you'll probably sue me. And you probably should. So there's a lot going on here. And going to expression, I'm going to look at US v. O'Brien. This is going to happen in the late 1960s, I believe. Starts in 68, gets decided in 69. This is about protesting the Vietnam War, which, by the way, is the thing a lot of people protest. Here at CTC, if you ever want to come down to the library, you can see the statue of Lyndon Johnson. And Johnson had to keep up this unpopular policy. He felt he had to. So it's definitely one of the things that's going to cost him the election in 68. He decides not even to run. He famously says, if nominated, I will not run. If elected, I will not serve. Takes himself out, even though he's the sitting president. And he had to face a lot of profane chants. I won't give you examples of those, but I can give you examples of others. Individuals would stand outside the White House and say, hey, hey, LBJ, how many kids did you kill today? We were drafting young people, sending them to Vietnam. But people had to be able to express themselves and say, we don't like this government policy. And by the way, once more people get on the bandwagon, you definitely see courts easing off and saying, well, the government doesn't have an interest in protecting itself. You got to be able to criticize the government, but there will be lines drawn. That's why US v. O'Brien is interesting. The courts are going to establish some forms of protest are okay, some aren't, depending on how they're conducted. For instance, this case involved an individual burning his draft card. Okay, and for those of you unfamiliar, if you're on the younger side, especially the fellas out there, guess what? When you turn 18, you don't really get to choose in this matter. You got to sign up for selective service, which means if we're in a military conflict, we're losing people, you can be called on to serve your country. Doesn't matter if you want to or not, which is what we were doing in the Vietnam War. And I can't give you much about the legal history of that because it's going back and forth. There are cases, I believe one out of San Diego that said women must, be compelled to sign up for selective service, but they've gone back and forth on that. So that's one with some interesting legal history, but no real changes. Small changes in the moment, not so much over time. That's still just kind of an interesting way to look. Well, O'Brien got his draft card, said, hey, you have to go. He burned it in protest saying, I don't want to do this. I don't want to go to Vietnam. I don't want to fight. I don't see the purpose. But in burning the draft card, as soon as he did that, the Supreme Court said we can't protect you anymore. One, it's government property. Two, it has a compelling government interest. And that interest is the United States had to conduct the registration system. They needed that card. By destroying it, he lost his freedom of expression. Therefore, he could be punished by the government. So that's one area. Also during that time, because this case is going to set a framework through which we can look at other forms of protests. In fact, you had individuals doing sit-ins at public parks. What they do is they just go, they'd protest, and then they'd stay, even after the park closed. They'd argue, hey, we're protesting, we want attention to tell people we don't like this policy, we want this policy to change. Their understanding was, we can do that, this is public land. But when it goes to court, it argues once they stay past closing hours, they pose a risk to public property. We all own that park, not exclusively them. All of us do. And by, various acts of vandalism, by just not following park rules, they're potentially harming public property. Therefore, the government has the authority to remove them. And that's not a violation of their First Amendment rights. You also had individuals wearing Black armbands symbolize that they didn't support the war. The court said that's fine. You're not getting in the government's way. You're not affecting the government's ability to do its own business, enact its own policies. You're not destroying government property. You want to wear it, it's on your person, that's fine. Same principle is going to apply to when people had profane clothing about the draft, saying, well, you can figure out the verb, the draft. Well, people may not like it. They may say that's obscene, which, by the way, is its own kettle of fish, but that's freedom of expression. That individual was protected when the state tried to punish him. The Supreme Court said, no, the state can't do that. It's not getting in the way of the government at all. He's allowed to do that. So that makes it tough. I mean, just a slight detour here. Obscenity, by the way, is just almost impossible for the government to understand. That's why it's such an aggravation to teach. We had a Supreme Court justice named Potter Stewart who said, I don't know what obscenity is. I'm not even sure what pornography is, but I know it when I see it. And hopefully when you hear, I know it when I see it, you can figure out that that's not useful to law enforcement. That's not useful for the government. That's not useful to courts. You're basically making every person a subjective agent. Useless standard. Later, there's the Miller case. They're going to come up with the SLAPS test. Just as useless because something can't be obscene or regulated by the government if it lacks serious literary, artistic, political, or scientific value. Right off the bat, what is art? I hate to go all 1990s on you, but what is art? That is so subjective that you can say almost anything you do is art. Believe it strong enough, get a good lawyer, you could probably, get yourself out of whatever predicament you get yourself in. So the government's just really bad at defining it. In their defense, I don't know if anyone else would be any better. So this is a weird one where the courts say, yes, the government can ban obscenity, but we don't know what it looks like. So once again, a standard's not enforceable if we can't identify what it is. If the speed limit said, hey, don't go too fast, that would be a nightmare.
Right.
Don't go over 75. Okay, we can measure that. We can understand that. So important. And a little closer to today, this is a court case actually from 2021. I believe I'm pronouncing it right, but I don't go to Pennsylvania. Mahoning Area School District versus BL. BL is a minor, so she is not expressly identified, just by her initials. She went to high school in Mahoning Area School District, didn't make the varsity cheerleading team. I feel for you, BL. That's unfortunate. But here's the issue. In a private Snapchat message, she just let it all go. Profane, ugly, angry, all those negative emotions you're feeling in the moment. Well, somehow school district found out. It's a private message to a limited group of people, so I don't know if someone looked over someone's shoulder, someone sold her out. I don't know. However, she got suspended. School found out. Now, credit to her and whoever had her back, they got this case to the Supreme Court. Took years, but they got there. And the Supreme Court took her side and said she should not have been suspended. But they're not going to say school doesn't have the right to suspend you for using your expression. It's how you use it that's important. And I wrote down the specific things. One, there was no substantial disruption of learning. She did it off campus, off hours. She wasn't disrupting anything. Two, it was private. She wasn't projecting this message. Three, she did not target any individuals. It was I dislike you in this wave, but it wasn't targeted. Because of that, the Supreme Court argued the school lacked the authority to punish her. She was using her First Amendment rights, and the school had to tolerate that. So that's just kind of a new one. I hope it doesn't open up any can of worms, but that's these are the things the Supreme Court's going to look at. It's not the morality of the issue, they're going to parse it down. What motivated your actions? How exactly did you act? These are the lines they're going to draw, and really redraw over the years. So, all right, let me move on because I did want to hit some of the due process amendments in our time because I think they're important too. Let's say the First Amendment doesn't have your back and you go to court. Well, it's good to know what can and cannot be used against you. Fourth Amendment protects you against unreasonable search and seizures. Oh boy, unreasonable. What does that mean? I wish I could give you a great definition. I really can't. It's whatever law enforcement can convince the judge signing the warrant is reasonable. I mean, there's latitude there. It's been refined and refined over time to where it's definitely a lot better now that we put it into practice, taken it to court and gone back, but there's still a little bit of latitude there. Also, there's some forgiveness there. Good faith exemption. For instance, you call a judge up at 2 in the morning, say, hey, sign this warrant. Judge agrees, yeah, you should search. Judge accidentally puts the wrong day because, hey, it's 2 in the morning. I might put the wrong date at 2 in the morning. Well, that was an honest error. They were working in good faith. The process was pure. There was a clerical error that can be forgiven. So information, evidence obtained during those searches may still be used in court. And we just passed 9/11, so I wanted to talk about something that deals with 9/11. 2001 court case, Kello versus U.S. Because after 9/11, we're all a little nervous. We're all a little skittish. For those of you who weren't there, it was a tough time. We all thought we were going to be mailed anthrax. It was awful. Well, government's going to take new and invented techniques to try to find potential terrorists and try to prevent the next 9/11. In doing this, they get pretty zealous. Congress supports them with the Patriot Act, which definitely reinterprets the Fourth Amendment in new ways that some stand up in court, some don't. But with Kello, and it may be Kylo, I've always seen it written. I've never actually chatted about it with someone. So if you're out there, I apologize if I got your name wrong. But what's going to happen here is that law enforcement at the federal level and even state level, depending on who they're cooperating with, start using thermal imaging to see through buildings. Like, oh, hey, there are people in there. We know they're bad. What can we discern that they're doing? Well, Supreme Court's going to say this is a violation of the Fourth Amendment. And I had to write this down because this is kind of bloated. They're going to say the government used a device that's not in general public use. This isn't, a traffic cam that just happens to catch someone. The government's targeting specific individuals, specific buildings with this to explore details that would be unknowable without physical intrusion. Therefore, it's a search. It requires a warrant. The government tried to argue, hey, it's just thermal. We pointed it. We technically never entered. If we never entered, we technically didn't search. Supreme Court didn't buy that. So even though the Fourth Amendment definitely got reinterpreted in ways that helped the government search post 9/11, it wasn't 100%. So an important case just kind of bring out. Fifth Amendment. I can't go through every little thing. It's massive. But I will hit on double jeopardy. Double jeopardy is this idea you can't be tried for the same crime twice. And this goes back to incorporation. If something hasn't been incorporated, that means it only applies to the federal government. Going back to double jeopardy, the federal government can't try you for the same crime twice. But states could if they didn't put it in their own Bill of Rights. By the way, some states didn't put it in their Bill of Rights, such as Connecticut. So here's the Palco case in a nutshell. Palco, in the commission of a robbery, kills a security guard. Palco's brother's there too, by the way, but we're just focusing on Palco. Palco goes to trial, loses, gets sentenced to life in prison. Done deal. Connecticut isn't satisfied. They're saying, you know what? We think if you gave us another chance, we could get a more severe penalty. So they drug him out of jail and tried him again. This time as a capital case. He lost again and was sentenced to death. So Palco's like, this is double jeopardy. I have a right to be protected from double jeopardy. Connecticut said, no, you have a right to be protected from double jeopardy from the federal government. This disagreement went up to the Supreme Court. The Supreme Court is going to take Connecticut's side. They're saying double jeopardy is not a right. It's just something the federal government can't do to you. So Polka was executed. 30 years later, the Supreme Court will change its mind. And they will say, you know what? Protection from double jeopardy is a right all Americans enjoy. States can't do it to you either. But that was too late to do anything for Polka. And I can't say whether he's a good guy or a bad guy. I never met him. You can't really dig a lot into the case and learn about him personally. So I can't pass moral judgment on this. I can just tell you it's an event that happened. Also, in the Fifth Amendment, you have a right to protect yourself. The important thing here is when you go to court, it's the government's job to provide enough evidence to suggest you did it. It's not your job to help them. That's why you're the defendant. You're supposed to go there and defend yourself. Hire a good lawyer. To that end, you have Miranda rights whenever you're interrogated. Right to remain silent, etc. You've probably seen it in movies, TV. Well, that wasn't really understood until the 1960s, so it just applied to the federal government. After the Miranda case in the 60s, it then applies to the states. But even then, Hollywood kind of misunderstands it. It's not when you're getting arrested. Doesn't matter. It's before you get interrogated. And it certainly isn't a get out jail free card. It's just if they don't read you your rights, any information in the interrogation, like if you told them, I did it. But if they didn't read you your rights, they can't use that against you in court. But guess what? They probably have a lot of other evidence they're probably going to use against you in court. So not a guaranteed win. And to that end, you have a right to an attorney. But once again, this wasn't understood to apply to every law, just federal law. If the federal government said you did something, you have a right to an attorney, whether you could afford one or not. Well, what if the state said we don't care? That happened. Florida didn't have any such right in its constitution. If you were too poor to afford a lawyer, tough. Good luck. You'll still have your day in court. Maybe you'll be visited by the lawyer fairy and you'll get magical law knowledge and you'll find a way. Well, Gideon didn't find a way. He had to defend himself and it didn't work out. This leads to Gideon v. Wainwright. This goes all the way up to the Supreme Court. And the Supreme Court is going to say, Florida shouldn't have done this. The right to a lawyer, regardless of whether you can afford one, is a right all Americans enjoy. States can't have laws that force people to defend themselves. You may choose to defend yourself, which is probably going to be one of the worst mistakes you ever make, but you cannot be forced to defend yourself in court. So with these, fourth, fifth, and sixth, we have due process. You have the right to protect yourself in court. You have the right to tell the state, it's your job to get me. It's my job to not get got, which I know is not a professorly thing to say, but sometimes it gets the message through. So with the Bill of Rights, and it's just simply too big to go through all of them, what we're understanding is that what's going on with the courts, what's going on with the corporations is incomplete, sometimes doubling back process, where understanding rights is tricky. And this kind of leads me to my last point, the Ninth Amendment. By the way, look up the Ninth Amendment. Try to read that and convert it into English. It's harder than you think. I'm going to sum it up for you. The Ninth Amendment suggests more rights exist beyond what's identified in the Bill of Rights. This was Hamilton's fear. This was Madison's fear. Jefferson wanted the Bill of Rights. Like, hey, we need to tell the government what it can't do. That's the whole purpose of the Bill of Rights. Madison and Hamilton were scared that if we can only agree on these, select few things, that means government can touch everything else because we didn't forbid them to touch it. They were alarmed. So the Ninth Amendment's kind of a win for them to say, in 1790, we've identified these rights, but there may be more that we haven't identified or that we won't be capable of identifying until we can understand it in the future. And that's what the Supreme Court's going to lead on when it reinterprets things. Oh, Ninth Amendment says there are more rights out there. Okay, that gives us latitude to identify them. That's going to be really important. I know the Ninth just never comes up in casual conversation, but it really should. It's very important, and it may help one of you in the future. Maybe one day courts say, yeah, you do have that right. And the Ninth Amendment gives us the ability to do it. So while this isn't a comprehensive look at the Bill of Rights, hopefully it just broadens an understanding of what the courts are looking at when they're identifying rights and identifying how we can and cannot use them. And I'll let that be the end of my discussion.
That's great. Thank you for that. I have a few questions, and if anyone has any questions, make sure you put it in the comments and we'll get back to you on that. We won't get, back to you in this video, but we will get back to you on the questions. One of the questions I have when you were speaking about the First Amendment, um, I've read recently that one of the states is thinking about putting pastors into their school systems rather than like counselors or in addition to counselors. And there's a big argument of, well, that's not going to work. um you know it are things like this happening all the time, like the governor in Alaska that went, okay, I'm making a decision about guns. um are these challenges like all the time happening, and it mainly depends on if someone gets hurt or if it affects the state or the country? Is that usually how these arguments end up?
Well, nowadays it's become almost for lawyers a cottage industry in itself. I mean, there are thousands, perhaps, maybe tens of thousands that are filed. Because it's court, take your shot. If you can afford to, and it's usually interest groups funding a lot of this, take your shot. Maybe you'll win. And then that $100,000 investment is going to pay off in a way you want because the law will be read in a way that's preferable to you. So, absolutely. And it just depends. For instance, if we get back to the First Amendment, nowhere in the Constitution does it say there's a separation of church and state. That was Jefferson's hope. Jefferson hoped, like no man has hoped before, that we would do that. But the government has carved out a niche to where there is an area where church and religion can work together. We used to have the limit test, that's gone as of 2022. Now it's based on historical understanding and practices. Like, have we done this historically? Have we done things like this in the past? If you can argue that, then you can probably argue First Amendment protection. They can do it. But even then, you still have the Establishment Clause, so you would have to open it up to all churches. And that could be, maybe the bridge too far for some people. They're like, well, yeah, I like my guy, but I don't know if I like that other guy. So that would definitely be interesting. But again, I can't predict how the courts are going to go. I know how they have gone, but that doesn't mean anything for the future. That's why this is a tough area for a lot of people because there's change, there's variation. What's true today could be radically different in 9 months. Just how it goes.
um just from reading the news, and of course you've got bias here, there, and everywhere, but would you say that the Second Amendment is probably the biggest fight um of all times, on the one that's most challenged?
I don't have numbers in front of me, but I'd probably say no, just because in the court cases, it's mostly one direction once it gets to the Supreme Court. They usually argue for broadening our understanding of the Second Amendment. For instance, states would have gun-free zones, and then the federal government would be like, no, you can't really have those. It's a right to bear arms, so you can't restrict that. The recent case, New York Pistol Association, I think it's Pistol and Rifle Association maybe, challenged that some locales like New York City, Boston, for instance, had a certain clause in their carry policy. It was called may carry. You may carry if they approve your reason. So if you were a security guard on a Brinks truck, yeah. If you were just, a regular person wanting to carry, it you had a greater chance of being denied. So that case went to the Supreme Court. The Supreme Court interpreted it broadly, saying there is a right to bear arms, so they can't be that restrictive. So now we have, states, depending on, what state it is, also cities trying to rewrite their laws to comply with that. And again, they're using a similar test to the First Amendment, historical understanding. What's going to qualify as a historical understanding depends on the judge you get. Maybe one judge says, hey, we've never done it, so I can't say it's constitutional to do it. Maybe someone's been studying Tombstone and said, hey, Virgil Orr banned guns in Tombstone, so that's a thing. I highly doubt that, but once again, it depends on the judge. And these are individuals with their own views of the law, their own nuances, even though we try to paint judges and justices with a broad brush. There are going to be a lot of issues where they disagree, even if they seem to agree on all the big ones. So it's one of those, let's wait and see.
Well, I've come across in my life people who have never actually read the Constitution and the Bill of Rights. By the way, guys, we have little Constitution books that tomorrow, Thursday, we're going to make available this week. So it's not that big book; it's a little tiny book, and you know, read it to see what's in it because people are always throwing around rights, 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 and they don't even know what's in the Constitution, what's in the Bill of Rights. And so it's just probably a good idea to read it, you know.
And it is one of the smaller constitutions out there.
Hmm.
I
Yeah.
mean, compare that to Texas. Texas has about 10 more articles and about 500 more amendments. So, U.S. Constitution is surprisingly small.
Well, what's that saying? Everything in Texas is big.
Even our constitutions.
Yeah, even their Constitution. Wow. Well, thank you so much. And then, guys, if you want any more information, definitely make sure to ask your questions in the comments and take the class. That
Free
would be great
advertising.
too. So, thank you so much. And this was a spur of the moment. Hey, can you do this for me? So you did a great job in
Thank
in
you.
in like 24 hours. So thank you. We truly appreciate it.
You're
And
welcome.
yeah, well, you guys, y'all have a great day. Remember to look at our events page because we have a lot of events. Like next week, we have Hispanic Heritage Week. We're going to have a cooking demonstration on one of the Hispanic heritage dishes. So, oh, and contests. We have the horror video contest, the pet photo contest, and we have a poetry slam and open mic coming up. So lots of contests to get involved with. You guys just have an awesome day and thank you again. We'll see you later.
Right.